Testing 1, 2, 3. This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant or expert witness, an author, and producer of these videos. Today it's time to speak about the role of an insurer's attorney after ending an examination under oath, or EUO. A well-executed EUO is not only one of the insurer's most effective weapons against fraud, it can be also highly instructive for the insurance claims professional or adjuster. If an attorney is responsible for performing the examination, the adjuster must make clear that it is his or her obligation to provide sufficient factual information supported by legal authority for the insurer to make a decision on the claim. The adjuster should also, if possible, attend the EUO to help the attorney and to study questioning techniques. Attorneys whose profession is to ask questions will usually do a more thorough job of an EUO than will insurance claims staff. After the EUO, the attorney will usually suggest additional investigation and can also give the adjuster legal advice as to the insurer's rights, duties, and obligations concerning the claim the EUO was designed to help complete an investigation. Counsel's report should include all the facts necessary to support any decision, whether learned in the course of the investigation or from testimony at the EUO. The adjuster must then analyze the facts in relation to the statutory and case law, and only then will he or she be in a position to make a fully informed decision on the claim. More often than not, the examination will cause the insurer's attorney to recommend payment of full indemnity to the insured. If the attorney advises the insurer that indemnity should not be paid, the adjuster should carefully analyze the recommendations to independently verify that there are sufficient facts supported by the policy language and legal precedent to support the conclusion. It is the claims person and claims management who make the decision, not the attorney. Decisions made by insurers must sometimes be based on reasons other than a strict reading of local law. Insurers should use the EUO tool judiciously. It should only be used in cases where the insured is unable to prove his or her loss, when the insurer's proof is inconsistent or incomplete, or when the insurer has a reasonable belief that a fraud is being attempted. Used properly by insurers, adjusters, and insureds who are intent on proving or obtaining only the indemnity promised by a policy of insurance to which they are entitled, the EUO will help the insured and the insurer fulfill the promises they made each other at the inception of the policy. After the EUO, a transcript of the testimony is prepared and delivered to the witness to read, correct, and sign under oath. The transcript then becomes a part of the sworn proof of loss required as a material condition of every first-party property policy. The insured is provided a reasonable time to complete the task. Most will do so quickly, since there is no obligation on the part of the insurer to pay until the EUO condition is met. When the insured fails to correct and sign the transcript of the partial or incomplete EUO, courts conclude that an insured materially breached an insurance policy by failing to submit to an EUO as often as may be reasonably required, or failing to answer material conditions. In New York, for example, in a case where it was undisputed that when requested to do so, the insured refused to sign the transcript of his EUO. The matters that must be resolved are whether the questions the insured refused to answer were material, such that he breached his obligations under the policy, which became a condition precedent to recovery of any indemnity. And if so, whether, in this case, a person named Longwell's offer to answer the questions and to sign the EUO transcript in a tardy fashion cures his breach under the contract. The court found that the insured's belated offer to answer the questions and to sign the EUO transcript did not cure the breach of his obligation under the policy, as too much time elapsed defeating the purpose of the cooperation clause and the examination under oath clause. This was a case called Allstate v. Longwell, decided in 1990 in the Southern District of New York. Insurers must be aware, however, that the failure to sign the transcript must first cause some prejudice to the insurer. In one of my cases, when the insured corrected and signed an examination under oath transcript, she corrected it to basically admit to insurance fraud, saying that she had lied under oath. This will happen almost never, and has only happened once in my 53-year career. As the Second Circuit Court of Appeal said, we realize, of course, that a signed transcript is of little value to the insurer if the insured keeps it. The policy's fuzzy language, however, coupled with the insurer's failure to demand that the insured return the signed transcript, and the insured's cooperation during earlier parts of the insurer's investigation, persuaded the court that the insured's failure to return the signed transcript did not warrant the drastic remedy of dismissing the insured's suit. This is a case called Varda Inc. v. Insurance Company of North America, a 1995 decision of the Second Circuit. A refusal of the insured to answer material questions at an EUO, provided for in the policy, shows a failure to give the insurer that degree of cooperation required by the provisions of the policy and is a violation of the agreement of the insured to submit to such an EUO. Where the insurer has reason to suspect arson or some other attempt to perpetrate a form of insurance fraud, it is relevant and material to inquire into the financial condition of the insured, because an insurer is entitled to develop circumstantial evidence of the insured's involvement in the suspected arson. It is beyond any dispute in Maryland and other states that the insured breaches the insurance contract when he or she refuses to submit to an EUO. In Phillips v. Allstate, a decision of the Maryland Court of Appeal, where the court held that an insured breached the contract when he appeared at an EUO but refused to answer relevant material questions, the failure to answer questions that are relevant and material to an insurer's liability for a loss and the extent of that loss constitutes a failure to comply with a policy requirement to submit to an EUO. Furthermore, the breach entitles the insurer to disclaim coverage even in the absence of a showing of actual prejudice, even when the insured follows the advice of an attorney in refusing to appear at EUO or produce documents requested. The courts will conclude that the condition of the policy has been breached and the insured forfeits the right to recover indemnity from the policy. Of course, the insured then is not without a remedy. He can always sue his lawyer for giving him bad advice. For example, in Bainbridge, Inc. versus Cal Farm, a California Court of Appeal decision in 2004, Bainbridge was found to have breached its contractual duty to cooperate with the investigation of the insurer of his claim by failing to provide documentation requested by Cal Farm. The court concluded that the breach was substantially prejudicial to Cal Farm because Cal Farm could not assess Bainbridge's claimed loss without the requested documentation. Cal Farm was therefore entitled to judgment as a matter of law, and Bainbridge obtained nothing. In Abdelhamid versus Fire Insurance Exchange, a 2010 decision of the California Court of Appeal, the court concluded that Abdelhamid's purported reliance on the alleged advice of counsel in refusing to answer Fire Insurance Exchange's questions and failing to supply requested documentation did not excuse her failure to comply with the policy conditions requiring her to supply the requested documents and answer material questions at her EUO. The insurer properly denied coverage on the basis that her failure to comply constituted material breaches of her contractual duties. An insured breaches the duty to cooperate by sitting for an EUO but by refusing to produce sufficient records, including financial, car payment, and maintenance records. In addition, in Robinson versus National Auto and Casualty, a 1955 decision of the California Court of Appeal, where the insured's refusal to answer material questions during an EUO were found to be breach of the duty of cooperation. And in West versus State Farm, a 1989 decision of the Ninth Circuit, the insured West was required to testify at EUO, even though he had answered the same questions in a preliminary interview. His refusal to testify deprived West of the right to the benefits of the policy. And in Bergeron versus Employers Fire, a 1931 decision of the California Court of Appeal that is still good law, the insured did not fulfill his obligation to complete an EUO, and as a result, Bergeron stood before the Court of Appeal, having recovered a judgment upon an express contract, one of the conditions of which he failed to perform. The Court of Appeal, relying on the California Supreme Court's decision from 1920 in a case called Hickman versus London Insurance, concluded that when he commenced the suit, he was without a cause of action because of his failure to testify at EUO. The EUO and the requirement that insureds produce relevant documents in the event of a fire or other loss are essential tools to insurers faced with a possible fraud or other issue affecting insurance coverage. Insureds and their counsel will often argue that they are not required to produce tax returns or other financial documents because to do so would violate the so-called taxpayer's privilege or right of privacy. They may refuse to testify about subjects they claim are irrelevant or protected by a privilege or right of privacy. In most states, refusals to testify or produce documents can and often do result in a forfeiture of claims presented by the insured. This video was adapted from my book, The Assurance Examination Under Oath, Second Edition, which is available from Amazon.com as both a paperback and as a Kindle book. If you found this video to be of use or of interest to you or your colleagues, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future videos and blog postings. Thank you for your attention.